Hello and welcome to Module 9 of Real Estate Management. That is managing tenancy management and dispute resolution. So in this module, we shall be looking at tenancy management and dispute resolution. That is managing landlord-tenant relationship and legal conflicts in Nigeria. The module content that we should be looking at include landlord-tenant relationship, rights and obligation of landlord and tenant, rent control and tenancy laws in Nigeria, step-by-step guide on how to eject a tenant legally in Nigeria, handling rent default, property damage, and dispute resolution before we now draw a valid conclusion. Let us begin with the introduction, that is Nigerian context. Rapid urbanization and housing demand make tenancy management vital. Why this model matters? Because one, it prevents costly legal disputes. It protects landlords' investment. It ensures tenants' security and rights, and as well as promote professional rentals market. Key topics covered in this model include landlord-tenant relationship, rights and obligations of both tenants and landlord, rent control and tenancy laws in Nigeria, legal eviction process, and handling default, damage, and dispute. Having known that, let us look at understanding landlord-tenant relationship. Landlord-tenant relationship is a legal and contractual arrangement where landlord grants tenant possession of property in exchange for rent. The nature of the relationship is usually one, contractual. That is to say, the relationship is based on agreement. Number two, mutual obligation. That is to say, both parties have rights and duties to perform. Then number three nature of the relationship is that it is legally protected. That is to say that the relationship is legally protected by the state law as well as the Land Use Act. Now let us look at types of tenancy in Nigeria. One, we have periodic tenancy. This is a type of tenancy which rent is paid on a fixed time period, that is either monthly or quarterly or yearly basis. Now we have fixed term tenancy, which is a type of tenancy which rent is paid for a particular period of time, usually 1 year. We have tenancy at will. In this type of tenancy agreement, no formal agreement. The tenant is just occupying the property at landlord's will, which may be terminated by any of the party. Now we have tenancy at sufferance. This is a type of tenancy whereby the tenant continue to occupy the landlord's property even when the tenancy agreement has expired. Let us look at the rights and obligations of landlord. Landlord's right. One, the landlord have the right to receive his rent as agreed. The landlord also have the right to recover his possession through legal process. The landlord have the right to inspect the property with reasonable notice. The landlord also have the right to enforce lease terms. Then let us look at landlord's obligation. The landlord's obligation include one, to maintain property in habitable conditions. So the landlord have the right to maintain the property. The landlord also have the right to provide essential services if agreed, such as electricity, water, and waste disposal. Number three obligation of the landlord is to respect tenants' quiet enjoyment. Then number four obligation of landlord is to follow tenancy law, no illegal eviction. So these are some of the rights and obligations of landlords. Now let us look at the rights and obligation of tenant as well. Tenant right. The tenants have the right of peaceful occupations without interference from landlord. So the tenant has the right to occupy the property without landlord's interference. Number two, the tenant have rights of protection from illegal eviction. That is to say that the landlord does not have the right to evict the tenant illegally. Number three, the tenants have the right to request for necessary repairs when the needs arise. The tenant also have the right to fair and clear lease term. That is to say the terms of the lease agreement should be clearly stated to the tenant. Now, the tenant obligation include one, the obligation is to pay the rent as at when due. That is, pay the rent on time. The tenant also have the obligation to take care of the property where he occupies in order to avoid damage. The tenant also have the obligation to follow lease term, no illegal subletting. So the tenant does not have the right to sublet his apartment to a third party without landlord's consent. The tenant's obligation also include the obligation to report any defect promptly to the landlord. Now let us look at rent control and tenancy laws in Nigeria. The legal framework of rent control and tenancy laws in Nigeria is that it is primarily state-based legislation. That is to say that this legislation varies across the state. For example, Lagos State have Lagos Tenancy Law of 2011. Rivers State has Rivers State Tenancy Law, as well as other states. Now, the key objective of rent control and tenancy laws in Nigeria, one, is to prevent arbitrary rent increase. So the objective uh, 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 is to for landlord not to increase rent arbitrarily. Number two is to protect tenants from unlawful eviction. So these are the objective. Number three objective is to provide clear eviction and dispute resolution procedure. Then number four objective is to ensure security of tenure. That is to say, the tenant will enjoy his stay without illegal eviction. Now let us look at rent control features as it varies state by state. One, it limits on advance rent, which is often maximum of what? 1 year. A notice is required for rent increase. Then three, protection against sudden displacement. So these are the features of rent controls as it varies according to the state. Now let us look at ground for legal eviction. That is to say, a landlord cannot evict arbitrarily. So a landlord cannot evict a tenant illegally. Valid ground must be followed. One, non-payment of rent. So for a landlord to evict a tenant, the following must be applied. So when a tenant fails to pay his rent as agreed, then it serves as a ground for eviction. Then breach of lease term. So when a tenant breach the agreed terms, maybe subletting the apartment to another to a third party without landlord's tenant consent, it is called breach of lease term. So it is a ground for eviction. Then number three ground is property damage beyond wear and tear. So when the tenant damages landlord's property, it is a ground for eviction. Another ground is tenancy expiry without renewal. So when the tenancy agreement expires without renewal from the tenant, it serves as a ground for eviction. Number five is landlord's genuine need to repossess with proof. So when the landlord wants to repossess his property with a proof, it will also serve as a ground for legal eviction. Then self-help eviction, locking out utility cut is illegal and punishable. So the landlord does not have the right to lock out or cut utility of the tenant, utility services of the tenant, which is illegal and it is punishable by law. Now let us look at step-by-step legal eviction process. That is to say, the procedure to evict the tenant legally from the apartment where he or she is occupying. Number one, establish a valid ground. So for a landlord to evict tenant legally, the landlord must first of all establish a ground, which is usually a rent default. Number two, review the tenancy agreement for terms. So the landlord need to review the tenancy agreement to ensure whether the tenant has deviated from the tenancy agreement. Then if the tenant deviate, then number three step is to serve a valid quick notice, which must be in written form with a statutory notice period. So the landlord will now serve a quick notice to the tenant. For a tenant of for a weekly payment, a 7 days notice will be given. A tenant of a monthly payment, a 1 month notice will be given. The tenant that pays on quarterly basis, a 3 months notice will be given. While that of tenant that pays yearly, a 6 months notice should be given to the tenant. Now let us look at number four step is if the tenant fails to vacate from the property, then the landlord will now, after the expiration of the quick notice which has been served, the landlord will now serve notice of intention to recover his property, which usually is 7 days final warning. Then if the tenant refuse to vacate from the property, the landlord will now file a court action, that is recovery of his premises suit. Then at the court, at number six step, obtain court judgment and writ of possession. So it is the court that will enforce eviction. So number seven process, the court enforces via court bailiff. Only the court can physically evict the tenant. So these are the process or step-by-step approach to evict a tenant legally. Let us move further. Let us look at handling rent default. That is the practical step. Immediate action. These are the step-by-step approach to handle rent default when the tenant fails to pay. Number one approach is early communication, where you have to communicate to the tenant in a polite manner. So polite reminder is needed. Then number two approach is formal demand notice, which is usually in writing. So the landlord will write a formal demand notice in order to recover his rent, which is usually in a written form. Then negotiate payment plan if visible. So another approach is you negotiate your payment plan. If the default continues, then the landlord will now issue statutory notice, that is quick notice. Then if the tenant refuse to vacate after the expiration of the quick notice, the landlord will now begin legal eviction process, as we have just explained. Then the last step is claim arrears in court. So the court will help the landlord to claim his arrears during the court judgment. Now, there is important tips here to note. The landlord should not lock out, seize belongings, or harass the tenant. It is the court that have the right for legal eviction. Then let us look at managing property damage. Steps for landlords. Number one step for the landlord is to document the damage. That is using maybe photograph, video during inspection. The landlord have to document the damaged property. Then the next step is to notify the tenant in writing. That is request for repair or compensation. So the landlord will now notify the tenant in form of writing. Then number three approach is use security deposit if allowed by the agreement. Provide itemized deduction statement. So if there is a deposit made by the tenant, the landlord will use the security deposit as stated in the agreement. Then if there is not, the landlord can also take a court action. That is if damage exceed deposit or tenant refused for liability. Then tenant's duty. The tenant's duty here is to avoid damage beyond normal wear and tear in order to avoid court action. Having known that, let us look at dispute resolution mechanism. That is to say, how to manage dispute between landlords and tenants from the least to the most formal. Number one approach is negotiation. This approach involves direct discussion between the parties. That is, the landlord and the tenant will just negotiate on how to settle their dispute. This approach is usually fast, cheap, and preserve relationship. Then number two approach is mediation. Mediation involves involvement of a third party to assist, which is often through rent tribunals or housing authority. It is usually non-binding unless agreed. So this is another method for dispute resolution mechanism. Then number three mechanism is arbitration. Arbitrations involve the use of arbitrator who makes binding decision. This method is faster than court. Then the fourth mechanism is litigation, which involves the use of court. So the court will now settle the action. So this method is time consuming, mostly expensive, but it's a legal final. It's legally the final approach. In conclusion, let us look at the takeaways and best practice. For landlords, use written agreements. Follow legal procedure for eviction. Maintain your property and respect tenant rights. Keep records of everything. Then as for the tenant, pay your rent on time and get receipt. Report issues promptly. Know your right against illegal eviction. Document property condition at move in or out. Finally, for both landlord and tenant, communicate clearly and early. Try negotiation, mediation before court. Know your state tenants law. Thank you.